as ministers in the temple of justice.
For anyone on the bench of the Nigerian judiciary, this chamber is the ultimate.
Let us all strive to maintain the independence of the judiciary so as to ensure the rule of law.
And the fact that the ministry is responsible for prosecution of cases makes the ministry very visible naturally.
If it is to buy time, you know who is buying time.
Becoming the first woman in the country to discharge the function. To me, Allah wishes that too.
Welcome to the program, The Scale of Justice.
Tune in every Monday at 2:05 p.m. and repeat broadcast comes up every Wednesday at 6:30 a.m. on the network service of the NTA. Keep a date with us.
Hello, welcome to The Scale of Justice, and I remain your regular presenter, Femi Okeowo, with the pleasure of having you on today's edition. On today's program, we shall continue our focus on the comments of key personalities in the nation's justice sector on how best the nation's judiciary can react to the continuous lockdown that we find ourselves occasioned by the COVID-19 pandemic. We actually have been talking to some personalities, the Minister of Justice, the FCT Chief Judge, and a practicing legal practitioner on how best Nigeria can overcome this, particularly when it comes to the justice sector. But before we go into concluding those interviews, let's first tell you that the judiciary itself has started to react positively in this line. Now, if any organ of government must remain functional and continue to perform its duties in spite of the lockdown, then such organization must be heavily dependent on the internet and it must go virtual. And that is what has happened to the National Judicial Council, the highest governing body, the highest administrative body of the Nigerian judiciary, which has for the first time conducted its council meeting through virtual means. That is what we're going to start the program with. We're going to look at the significance of that and how it can translate into the justice sector for the country. So we go to the headquarters of the National Judicial Council, where the 45th meeting of the National Judicial Council was held through virtual means. This virtual meeting of the National Judicial Council has been a long way coming. Indeed, the process was started since 2012, and the situation in the country or in the world generally, the pandemic, has triggered this and made it faster.
Good morning, my lord.
Presided over by the Chief Justice of Nigeria, Justice Ibrahim Tanko Mohammed, the National Judicial Council is the highest administrative organ of the nation's judiciary. This meeting is a regular one in the running of the nation's judiciary. But in view of the COVID-19 pandemic, one of the items on the agenda of the meeting would be to fine-tune the use of virtual and internet processes for the circulation of court processes and judgments. But for now, The meeting and the administration of the judiciary in Nigeria does not have to draw the physical attendance of members. Like in the case of this council meeting, only 5 out of the 24-member council were physically present in Abuja, along with the secretary of the council, Gambo. Other members just remained in their jurisdiction and were part of the meeting through virtual processes.
This is the first time the council as a whole is holding an online meeting. But I must, however, say with all sense of modesty and humility that this is not completely novel to us here at NGC, because we've had course in the past to actually leverage on the ICT and similar platforms in discharging our constitutional responsibilities. So in the past, for instance, we have had course to hold different investigating committee meetings online, and we have had course for even witnesses to testify from the remote locations before the investigating committee meetings.
Since you have talked about witnesses, how will this translate into the use in courts? Would it?
Yeah, at the meeting, the Honorable Chief Justice and Chairman of the Council has constituted a committee to actually look at the possibility of how the courts will continue to function effectively despite the lockdown and the challenges posed by the COVID-19 pandemic. The Council has resolved and decided on a number of issues. One, which I've already mentioned, is the constitution of the committee to look at how possibly the court will continue to function despite the lockdown. And then the Council has also considered and recommended names of candidates for appointment to the High Court bench of the Federal Capital Territory. In addition to that, Council has also considered names of candidates to be submitted to the various state governors for appointment as head of courts of various jurisdictions.
And now we continue our series on the comments of key personalities on how the justice sector in Nigeria can positively respond to the lockdown that we find ourselves. We have been talking to the Minister of Justice and Attorney General of the Federation, and he is going to also talk about the prison decongestion program of the federal government. Courts are beginning to utilize the provisions of non-custodial provisions. We have always had the custodial provisions. How can our system absorb this and make it effective in the running of the law?
Well, you see, the non-custodial sentence is indeed a product of policy formulation by the government, is indeed a product of necessity that came about on account of the need to decongest our prison centers, our correctional service centers and formations across the country. As you rightly know, our prison service or our correctional centers are indeed congested to such an extent that 70% of the inmates in our correctional centers are awaiting trial inmates. Now, the need arose to look at the system and see what interventions we can bring about for the purpose of having a sustainable policy that will see to the decongestion of the prison formation. And that is how Nigerian Correctional Service Act came about, which is indeed a piece of legislation that is intended to support the decongestion process of our correctional service centers. So what happened? Arising from the piece of legislation, that is Nigerian Correctional Service Act, is bringing about those innovations that we believe and think are sustainable for the purpose of bringing about the congestion of the prison formation. And what has it succeeded in achieving at the end of the day? It has indeed succeeded in accommodating, by way of legislation, the non-custodial sentences for convicts. It has as well succeeded in ensuring that certain discretions are accorded the prison personnel in accommodating inmates. For example, for the first time in the history of Nigeria, a discretion is accorded the correctional centers formation to reject inmates in circumstances where they are indeed overcrowded and congested. Again, by that singular legislation as well, discretion is accorded them to reject an inmate that is presented without adequate and proper documentation. Again, the major and associated implication of the Correctional Service Act is the fact that people are now going into correctional centers for reform. So reform is the word as against punishment. And within the context of reform, for example, we have now developed skills acquisition centers. We have started and commenced the development of skill acquisition centers. For example, in Kefi, they have a very good and indeed fitted skills acquisition center, and they are producing product. Mr. President has taken the opportunity to put in place the Presidential Committee for Reform and Decongestion of Correctional Centers. Within a shortest practicable time, on zero budget basis, that committee has succeeded in setting free over 4,000 prison inmates. Shortly before, they have succeeded in visiting 16 states across the nation, and eventually succeeded in acquitting over around 4,000 inmates within the period, shortly before the COVID-19 pandemic set in. And as you rightly know as well, after the unfortunate incidents of COVID-19, the Presidential Committee, working with the Ministry of Justice and Ministry of Interior and Nigerian Correctional Service for formation across the state, have equally succeeded in securing the release of around 2,900 people.
That event, was it not a duplication of the functions of the Presidential Committee? Well,
it is. It cannot be adjudged as a clear case of duplication, because a necessity that calls for the lockdown, international lockdown, has indeed necessitated a revisitation or perhaps doubling of efforts for the purpose of ensuring that the correctional service centers across the nation are indeed catered for, addressed, so as at the end of the day, they will not run into the trouble of affliction and infection arising from the COVID-19. So it is a special case that calls for special measures, and it is indeed not a duplication per se, but a measure of necessity arising from the need to address, to assist the correctional service centers in ensuring decongestion of correctional service centers across the nation, so as at the end of the day, so as to ensure at the end of the day that we reduce to the minimum the possibility of affection and affliction of the correctional service centers inmates.
How have the states been responding so far?
Well, in fairness to the states, even before the unfortunate incidents of COVID-19, they have been very supportive and cooperative. As I stated earlier, the Presidential Committee on Decongestion of Correctional Centers has succeeded in securing the freedom of around 4,000 prison inmates before the coming in of the unfortunate incidents of COVID-19, the affliction. For example, at a visit in Kano, with the support of the state government, the Presidential Committee has succeeded in releasing around 5,000 inmates in Kano. 500 inmates in Kano at a go. And that is because the state government, working with the Presidential Committee and indeed the Federal Ministry of Justice, work together in terms of profiling those that were sentenced to, that were liable to payment of fine, and they are indeed working together. The fines were paid, as a result of which about around 500 people were released at a go.
We also have on the program the chairman of that committee, which was constituted way back in 2017 and has been decongesting prisons.
We were glad those that were granted an amnesty came as a result of the exercise that we had undertaken, and that of the Prerogative Mercy Committee of the Ministry of Justice. And we are happy Mr. President did approve the amnesty as we prayed. Now, that is within the competence of Mr. President. There are certain suspects or defendants that could only be released by the respective chief executives of the component states of the Nigerian nation. Now, the idea is, Mr. President having done what he could at the center, it is required that the respective chief executive of the various states of the Federation should in turn also do the same thing. And we didn't just advocated for something like that. We had, it is within your knowledge, as we were going around, we had done some classification as to convicts that were meant for certain governor or certain state governor to handle. So these statistics were used in directing the number of convicts per state for the governors to act. As I'm talking to you, I have received returns from quite a number of states, governors' action towards that direction. So you can see it's quite an encouragement, it's quite motivational, and as they release, they send the statistics to the Presidential Committee on Prison Decongestion reforms. At the end of the day, we will provide the details of such release. We are anticipating about 2,000, I think 600, to be released at the end of the day. And we are happy with the responses. If I show you the first, of course, part from now, the anxiety, the interest shown, others are saying, oh, we have not received any communication with from our governor. And I directed that, okay, get in touch with the head of the Correctional Service Center in your state. You get information. And then I sent to them the email of the secretary of the committee. And that facility from yesterday, almost throughout, I was engaged at home, communicating with them, asking them this is the way forward. And as I'm talking to you now, it's just about 2 heads of court, and it may be by the time I left home, the secretary would have reached them. So all hands are on deck towards ensuring such releases are made, and I think it's quite a motivational thing.
In some countries,
Yes.
releases are being done, but they are temporary, only in order not to have congestion in the prisons. They let them go and tell them to come back after the COVID-19 instance. Is there any?
No, we have not engaged in that. That's the issue of parole, okay. And it's a very good thing. Already a document has been articulated, and then the issue of suspended sentencing and what do you call it, the community service thing is being articulated. Sooner as we normalcy returns, the judges, the magistrates will be exposed to special technical training in that regard. Under the Administration of Criminal Justice Act, the position is that no arrest will be made until after the completion of investigation. All right? But as soon as they arrest without completing the investigation and they come before us to insist that there must be a remand order, the courts have no option. Lest the accusation again will come at the public domain, oh, the judiciary is simply releasing people that were arrested.
And now we have Ahmed Raji, a senior advocate of Nigeria, who just like most legal practitioners across the country, have been monitoring the situation and seeing how this affects their practice. He talks to us on suggestions and the way out in this circumstance. People are saying, are we equipped for the use of the non-custodial sentencing?
Why not? What is the essence of sending somebody to correctional centers? It's either to deter, to punish, or to reform him. But largely, it is to reform him, and then retribution. For example, if somebody has been accused and tried and sentenced, convicted for stealing, take the money off him and let him pay a token by way of punishment for what he has done wrong. The stigma is enough. So, but the congestion in the prison is not due to those who have been found guilty, but it is largely due to those who are awaiting trials. Okay. And that is where the system must have to look at it critically. And it should start from the investigating agencies.
Those who are sent on community service, for instance, or sentenced, their sentence is on parole, yeah, or suspended sentence, are they ex-convicts?
They are. Even if you are cautioned, okay, you are ex-convict. Conviction is different from sentencing. Okay. When you are charged before the court, the first duty of the court is to ascertain that you are guilty or you have committed the offense. Then it will now pronounce that you have been charged for this, I found you guilty, you are hereby convicted. Now punishment is sentencing, which may range from admonition, caution, imprisonment, fine, and as many as possible. So, all like that. Yes. So, but the conviction is there already. Okay. So, the manner of sentence, yes, is a different kettle of fish entirely. Okay. It's the punishment for the conviction that is the sentencing, which is governed by a whole lot of principles. So, whether you are cautioned, or you are asked to go and be sweeping the floor, or you are asked to be frog jumping, or they put a badge on your hand that you must not leave outside the city or within a particular radius or what have you, you are a convict.
These are the items we have on the scale today. We have tried to look at how the pandemic and the lockdown that has followed has affected the legal practice and the justice sector generally. And this will continue in the weeks to come. We'll see how best the justice sector of Nigeria comes out of this and how fast it comes out of this when the lockdown is over. Thank you for being part of this program. We shall be joining you on more emerging issues in the days to come. We'll see you again.